Well, good afternoon. Happy Friday the 13th, right? My name is Mona Hilton, and I would like to welcome you to Ready or Not, Here Comes HIPAA. It's kind of a funny but ironic coincidence that we're having this webinar on Friday the 13th because I think it's probably safe to say that none of you woke up this morning going, wow, I can't wait for HIPAA. And I can't wait for that September 23rd deadline. In fact, I don't think I've ever spoken to one person who is actually looking forward to it, including those of us around the table. Wouldn't you agree? So there is a deadline that's coming up, and our company, which is Genesis Global Technology, we work with a lot of medical and healthcare companies and clients, and several of them have gone so far as to say, you know, I really don't have time for all this HIPAA nonsense. I've got a practice to run. I've got patients to help. I'm just not going to deal with it right now. Well, unfortunately, sticking our head in the sand and acting like HIPAA doesn't exist is probably one of the worst things we could do right now because it actually opens you up for more liability. But we're going to address that in a few moments here. So just to kind of give you some background, back in early August, we sent out an email to many of you and said, what is your biggest HIPAA questions? What are some of the things that you're concerned about, and what would you like us to focus on? And you answered loud and clear and in large quantities. It's obvious we hit a nerve. HIPAA is a very scary thing, and even more scary, it's really a very unknown topic. So today's webinar is in response to that email. Some of you who responded know quite a bit about HIPAA and asked very pointed, very specific questions. But there are many people who HIPAA is a new topic, and you asked to be educated on the topic. So that's what we're going to do today. We're going to start with the basics. We're going to work our way into some of the specific details and some of the specific questions that you asked. So if you know a lot about HIPAA, hang with us. Some of this will be a review for you. But if you don't know a whole lot about HIPAA, this will be an eye-opener. I promise you that. Now, one thing before we get started, I want to make sure and emphasize that it's important for you to understand that HIPAA and HITECH really run in parallel, and they equally directly touch two areas of your business, the legal part of your business and the IT, or the computer technology. So what we have for you today is we have two experts. One is a legal expert, an attorney, who specializes in business law and HIPAA issues. And another one is a technology specialist who really specializes in HIPAA technology. So we'll be addressing both of those topics equally today because they often touch each other, and even sometimes legal and IT issues overlap a little bit. And you'll see a little bit more about that as we go on. So let's start with today's agenda to just kind of give you an idea of what we're going to cover today. On the agenda for today, we're going to do some introductions. I'm going to introduce you to the experts, our guests today. We're also going to talk about what is HIPAA, what is HITECH, and what is ePHI. Again, they may be familiar with you. If not, you're about to get educated. We're also going to address the history of HIPAA, why HIPAA is important to you, who does it affect, does it affect you, and then we're going to specifically address a lot of your questions during our myths and facts section, and we're going to talk about your responsibilities, your risks, how it really touches your lives and your businesses, and then how you can prepare for HIPAA and how you can protect yourself, and then we're going to give you some resources to address. One thing I just kind of want to tell you about is the format for today's webinar. Rather than a traditional webinar, we wanted to kind of change up the format a little bit for you. I think the three of us can say we've spent hours sitting around this table talking about HIPAA, talking about HITECH, talking about all the ramifications of it. I'd say at least a dozen hours. And the thing is, we thought it would be very interesting for you guys to listen in on these conversations. So that's what we're going to do. It's going to be very informal. We're going to ask the experts some questions, and then we're going to address them one by one. So you're going to kind of listen in as we have a roundtable discussion about HIPAA. Sound good? I'm going to assume you said yes. Let me introduce you today to our guests. Bruce Vanderlann, as I mentioned, is a business attorney with a specialty in HIPAA, and he has a lot of stories, a lot of facts, a lot of information to share with you. I can't wait for you to hear what he has to say. Also, our other special guest today is Kristen Day. She's the Vice President at Genesis Global Technologies. For those of you who know Genesis, you know that we do disaster recovery planning. We do a lot of computer engineering and maintenance, and we also do HIPAA risk assessments. And Kristen is our in-house HIPAA expert, and I can't wait for you to hear some of the tips and ideas and strategies she's got. For those of you who want to know, we will be recording today's session, so if you'd like to have a copy of it, we'll give you a way to get that at the end of this webinar. And I think many of you know me. My name is Mona Hilton. I'm with Genesis Global Technologies also, and I will be your host for today. So with that, let's kind of get into some of the meat of it. And let's start off with some basics. So Bruce, if you would, share with us what HIPAA, HITECH, ePHI, what they stand for, just kind of a 101, education one-on-one on what those are.
Okay, well, HIPAA is the Health Insurance Portability and Accountability Act of 1996. Originally, it was put into place to encourage putting patients' medical records onto electronic media. I think in 1996, that might have been a little overly optimistic because here we are 17 years later, and it's really just getting done now. And there are some ramifications for that. The HITECH Act is the Health Information Technology for Economic and Clinical Health Act. And it was passed in January of this year. It's what implemented the final omnibus rule for HIPAA, and it really is why we're here, why we're concerned about September 23rd, because that's when the final omnibus rule for HIPAA goes into effect. And ePHI is electronic protected health information for the patients.
Excellent. That's kind of a great segue, Bruce. If you don't mind, continue to give us a little bit about the history of HIPAA, why it was conceived, and kind of what it's grown into now.
Well, the background on why it was conceived was, as I said, to give patients the ability to move their records. If they moved, if they changed jobs, if they changed locations, the portability really in the early days was the focus of HIPAA. I think that over the years it has changed focus, and now the focus really is on the accountability aspect of HIPAA. I think you'll see as we go through this the different laws, rules, regulations that have layered on top of this since 1996. And as you see those, you'll see, if you compare with the stories I'm going to tell you later, how those layers have led to more and more enforcement and have led to more and more rules, regulations, and problems for the practices.
That's really good. Now, we know that HIPAA has already been instituted, and the first waves have already really started to shake the medical community. Can you give us some idea of some of the things that you've heard and the impact of HIPAA?
Absolutely. In 2011, Massachusetts General Hospital was fined $1 million for a breach involving just 192 patients' records. That works out to just over $5,200 per patient record. You think about the number of patient records you might have in your database of patients, multiply that times $5,200, you can come up with an idea of what a fine might cost you. The rule says that the maximum penalty per patient per violation is $50,000, but that's for if it's a knowing and willful violation. It's also the potential penalty for a violation where you had no idea that it would be a violation. So if you take $50,000 per patient record, and then you can go down each channel for a maximum of $1.5 million per violation. So if my records go out in an email, that's one channel. If patient records go out to a newspaper, that's a different channel. So every channel, if they're disclosed to an individual, that's another channel. So really, while they say there's a $1.5 million maximum penalty, there really is no maximum penalty. Some of the other, Idaho State University was fined $400,000 because someone in the university simply disabled a firewall. Nobody knows whether any records were disclosed, but simply disabling the firewall led to a $400,000 penalty. The state of Alaska was fined by the federal government $1.7 million for the theft of a USB drive, which may or may not have contained patient information. We've got things like a doctor at UCLA went to jail, actually. The doctor was just looking at celebrity records and not disclosing them. There was no sale of records to the Inquirer or anything like that. He was looking at patient records just out of simple curiosity. He went to jail, and UCLA was fined $850,000. Now, I know, because my wife is a physician assistant, my family's been in the medical community, I know that practitioners, always get asked to look at, Aunt Mary's records. Just check and see, is she okay? Is there something we need to be concerned about? Or asked to look at neighbors' records. You can't do that. That is a violation, and that can send you to jail. There are, on the other side, Signet Health in Maryland was fined $4.3 million for not giving patient records. 41 patients of Signet Health wanted their records, and Signet Health said, nope, we can't do that. We're not supposed to give out patient records. This is part of the misinformation of HIPAA. They're thinking we're not supposed to give out any information, and yet the other side of that coin is if you don't, you can be fined. That fine was made up of $1.3 million for the failure to provide the records to those 41 people and $3 million for failure to cooperate with the Office of Civil Rights. I think the disparity in the fine shows you where the focus is for the government.
Wow. And a lot of those sound like really innocent examples. You were telling us, I think it was yesterday, about a story of a hard drive or a flash drive that was misplaced.
Absolutely. You can be fined. There are stories of disk drives or flash drives that may have ended up in a janitor's closet somewhere. We don't know if they've been disclosed. They could have actually been destroyed, but we don't know that. But because we can't account for them, it can lead to a fine. The two biggest areas really that are leading to fines or have led to fines in recent years are theft of devices, theft of laptops, hard drives, things like that, backups.
Cell phones even.
Cell phones, absolutely. There's a thing that I've heard about called apple picking, where you're walking down the street talking on your phone and somebody comes along and grabs it. If you have patient information on there, even if it's an email on your smartphone, that is a breach of HIPAA. The other area is simply not having documents in place. This is a law where you can't just say, okay, I've got my documents, I've got my templates in place, now I'm done. You have to actually continually work that process, make sure that you have those in place, for both from my end and from your end, the technology end. You have to constantly be testing to make sure that your compliance solutions are in place and working.
So would it be safe to say that the way that we have done business in the past is no longer going to work? Being able to talk freely or to show information, is it safe to say that those days are gone? Those days are gone, absolutely. Yeah. So we kind of hit on this already, but HIPAA's been around since 1996. Tell us, why is September 23rd so significant? What makes that such an ominous deadline?
It's a deadline for implementation of compliance programs under HIPAA as it's affected by the HITECH rule, which was passed in January. It became effective in March and gave practices 180 days to get into compliance with HIPAA, and that, for lack of a better term, drop dead date is September 23rd.
And that affects everyone.
It affects everyone, and I'm sure a lot of the people listening in don't understand. It not only affects the healthcare practitioner, the doctor, the dentist, the practice itself. It affects the people they do business with. And then
Right.
we call those people business associates.
Right, and we're going to get into that in just a second. I want to just mention to the audience that there's a slide up with kind of a timeline that coincides with what Bruce was just telling you as far as what's happened, just so you can have a history of that. But that's actually a great point to bring up, because I'm sure if I was sitting at the other end of this webinar, I would be asking that question. So what does HIPAA mean? Who does it affect? Who falls under HIPAA regulations? I mean, obviously we know that medical practices, they're clear cut, but who else? Give us some examples. And I'll ask you, Kristen, the same thing when Bruce is done.
Well, it's accountants, it's attorneys, it's document shredding facilities, it's certainly IT companies. That's probably the first line right there, because everybody's we do everything electronically these days. But it also includes down to cleaning companies possibly. If they have the ability to see patient information, they're included as well. Anybody who may receive, create, transmit, or maintain any patient record, or what we call identifiable patient information, they're going to be covered by this. And it's a long chain. It's not only the practitioner and the attorney, say, me, but it's then the people that I do business with, my account who may see something, and it's the people that they do business with, and the people that they do business with. So it continues on. There's a very long chain of people who are affected by this.
So really it's anyone who could potentially have an opportunity to see patient data.
Yeah.
Right, and I would add to that document management companies, and you may have mentioned shredding companies as well, but anyone who comes in contact with that data or could potentially come in contact with that data.
Or even other patients who are looking over a counter and looking at, I know you were telling us the story yesterday.
Well, I was. The other day I went to the doctor, and I'll tell you, I got great service there. I had a fabulous experience, but in the first 3 minutes that I was there checking in, I saw at least 2 HIPAA violations, 2 that I'm absolutely certain of. I could see other patient information, identifiable patient information, and the Notice of Privacy Practices was probably 10 years old. It was way out of date. And the combined cost of those 2 violations alone is $100,000.
So a lot of these things aren't even major changes, just education of their staff as to what they can make viewable, what people can see, where they have their monitor positioned.
Absolutely, and that's really the way HIPAA works. It's not only the IT side and protecting the electronic transmission of records and storage of the records, but it's also the plans and policies and procedures in place. It's on both ends.
Mm-hmm. Now, I know you kind of touched on this a little bit, but one of the questions we had was asking, what about non-for-profits and state agencies and those kind of people? They fall under HIPAA, correct?
Absolutely. That's one of the examples I gave was the state of Alaska. You know, it's a state entity that was fined $1.7 million by the federal government, and this is going to be administered by the Office of Civil Rights. They're hiring new agents. They're going to be doing audits. They've already said we're going to be looking for violations, and the words they used, Health and Human Services and the Office of Civil Rights, is we're going to make examples of people who have breached HIPAA. And anytime your government tells you they're going to make an example of you, I think you should be very worried.
Right. So if you happen to fall asleep so far during the webinar, that should have woken you up. This is serious stuff. Now, you had mentioned business associates, and so all these other companies that, as you said, provide services to the medical community, they fall under the business associate category, correct?
That's right. And the covered entity, the practitioner, has to have business associate agreements. They have to have certain guarantees that the business associate agreement is following the rules and regulations as well. And it's not simply just a statement, yes, I am following the rules. It has to be verifiable. And then the business associate has to do the same thing with their business associates.
And their employees too, right?
And their employees too, yeah, absolutely. Well, like I said, the doctor went to jail. So there are individual penalties for violations as well as company penalties.
And if you're a covered entity, you should be asking your business associates for their policies and procedures.
Absolutely.
So specifically, what kind of information is protected, or not permitted for people to see?
Anything that's identifiable for that individual and is health information. And that includes, it also includes financial information. It's paying for, billing for services or paying for services. That also is individually identifiable health information, even though it doesn't have anything to do with a diagnosis.
Right. And you were telling us also the other day about a story of a physician walking down a corridor, seeing a patient saying, "Oh, what are you here for?"
Yeah, things like that, or saying something like, "Hey, how's your knee replacement doing?" That's, you can identify the patient and you just identified the diagnosis.
Right. All right. Well, very good information. I know we've got a lot of stories, and we'll kind of get into some of those. What I wanted to kind of segue into now is some of the myths and facts. I mean, we've been asked a lot of questions, and I know there's a whole lot of information that's swirling on the internet right now. I just wanted to ask you, Bruce, why can't we believe what we're reading on the internet? Why should we not take that as gospel?
Well, just because it's on the internet doesn't mean it's true, for one. It's just as a base, from a starting point. But also, if you do a search, things come up that are under the old rules. And if you're not certain of, if it's not dated, if you're not certain when that was produced, I've even seen things on the HHS website that are from 2002, 2003, and they're still up there.
But they're no longer accurate?
But it never goes, it's not accurate, right.
So some of the new laws and some of the new regulations override the old things. So just because you're looking at something, it might have been accurate at one point.
Right.
But it doesn't mean it's accurate now.
Right. Things are changing significantly as of September 23rd.
All right. So while no one has a crystal ball, let's talk about things as they stand now, and let's kind of address some of the specific questions that were sent in to us. And we talked about the business associate. We talked about the business associate agreement. Can you tell us a little bit more about that agreement?
Well, it's a contract between the covered entity and the business associate, and it lays out what the business associate is doing for the covered entity and what the expectations are, what the business associate can do and not do with information. And it gives the covered entity the, in part, it gives them the assurance that the business associate is doing what they're supposed to do with regard to HIPAA.
Good, good. All right, another question we got kind of goes into some of the technology, and I'll ask this to Kristen. They asked, I can see where HIPAA affects our practices computers, but what other hardware or technology is at risk beyond our computers? Kristen?
That's a great question. Yes, people typically know their computer is something that falls under HIPAA. Their servers fall under HIPAA. If they have a firewall, that falls under HIPAA. Any mobile devices, smartphones, laptops, any type of PDA, tablet, that falls under HIPAA. And a few lesser known items like fax machines and copiers.
Why a copier machine? Why a copier?
Yes, why a copier? Believe it or not, every time a copy is made, that information is stored on the hard drive. So that is retaining that personal health information.
Wow, that's, I would venture to say most people would have never thought of that. Now, what about regular phone systems and voicemail?
Voicemail, if your voicemail is being saved electronically and has data pertaining to those patients, that it can fall under HIPAA as well.
Wow. Now, we know that Office XP, Microsoft is retiring Office XP in April of next year. So will desktops, will computers that have Office XP be in violation of HIPAA as of April? And tell us why that is.
Yes, absolutely. I know myself, I took my daughter to the doctor within the last month, and that doctor's office is still using Microsoft XP as an operating system. And so they're going to want to make sure they've upgraded their OS from XP. And That's not covered under HIPAA because Microsoft will not be supporting Windows XP. They're not going to supply any updates, which will make that system vulnerable.
Yeah, I've even heard that there are hackers out there right now that are preparing for the retirement of Office XP to hack into Office XP machines. Is that true?
That's true.
Yeah, so if you've got Office XP on your machines and you're on this webinar, please, you need to make plans to upgrade those immediately or contact us.
And know that 9 out of 10 machines cannot go from Microsoft XP up to Windows 7 to be compliant. Most of the time that requires an entire new hardware configuration.
Wow. All right. Another question for you, Kristen, that we got was, my organization has implemented antivirus software on our server and all our computers and laptops, so we're in compliance, right?
Well, we all know having a good antivirus program installed on our computers is a good idea, but I would consider that just a first step in compliance with HIPAA. You want to make sure your server is covered. Any of those extra devices we just talked about need to be in compliance as well. Firewalls are important, and having procedures to document when those antivirus definitions are updated, what kind of procedures are in place if you do have a virus outbreak, if there is a disaster recovery plan in place and the server goes down. So yes, antivirus is important, but I would say that's just a first step in compliance on the IT side.
Right. And kind of a backup question to that is, I've heard that adequate data backup processes are sufficient for medical practices. Is that enough? And if so, why not?
If you have electronic personal health information, you may be in a situation where that information may need to be encrypted. It depends on your situation and your data. Not every configuration is the same. It's not a one-size-fits-all solution.
And don't they also have to verify their data backups? It's not just enough to back up?
Absolutely. The little-known practice that's covered in 45 CFR 164.308, if that matters to you, that requires periodic data recovery testing. So at least quarterly you're going to need to perform a reinstatement of at least one file to prove that your data backup system is working and in compliance.
Okay, good. Along those same lines, there was another question that they sent in saying, we are decommissioning a device we've used in the past. What do we need to know in order to do this correctly?
We touched on this just a few moments ago, but data lives on in the hard drives of those devices that you're decommissioning, whether it's a server, whether it's a computer, a laptop, or even the copier we just talked about. So you want to make sure that you want to have the policies and procedures in place that describe and track how you dispose of this storage material, but we recommend that you use an IT asset disposition partner that documents, takes pictures, tracks and logs, and provides you written verification that those assets and data have been effectively disposed of.
Yeah, and that's one of the legal requirements, that you have to certify that that data has been properly disposed of, and which could be one of the problems that these places that have been fined for losing hard drives may have run into. If they had it destroyed and they could certify that, they might have gotten out without a penalty.
Well, it's very overwhelming how much is involved and how much you have to think about that you never thought about before.
Absolutely, there are rules on both sides, and really they're complementary or very similar rules for both things. You know, when we're talking about what's required in certification, what's required in your plans. Kristen was talking about having to test your data recovery system. The same thing is true for your plans, policies, and procedures. You have to constantly monitor those, update those, and show that you've been doing that you're conscious of this, not just putting it in a binder and putting it on a shelf.
Mm-hmm. And that kind of answers another question that we got, which was that do we have to have a written policy on HIPAA enforcement in our organization?
Yes,
Yes.
absolutely.
Yes and yes.
Yes, yes, and yes. Just in case you missed that, the answer is yes. And as Bruce was saying, it has to be updated regularly. Like you said, you just can't put it on a shelf and forget about it.
Right.
What information about my patients do I have to keep protected under the HIPAA privacy rules?
Any individual identifiable health information.
Okay. And you kind of addressed this a little earlier on, but so our organization has bought some HIPAA templates. Is that enough?
No, absolutely not. First of all, this is not a situation where you can just say, okay, I've got an employee manual, and here's the manual, read it, sign it, and when we're done. The law requires that you have certain officers named as privacy officer, security officer, that they do certain things, that there be training involved, and it has to be a constantly monitored program. One of the great things that I've been seeing from different associations for the different types of practices or specialties is they're telling people this. They're saying, get these in place, but then work with people to make sure that you continue to be compliant.
And is there something to be said for showing attempts at getting towards compliance?
There is, and that will lessen the potential penalty. If you're showing that you're trying, then all indications from HHS and OCR are that they will take that into account if they're going to assess a penalty.
Wow. Okay, going back to some of the questions that we received, a couple of them were regarding email, and I'll ask the first one, which is, we have emailed patients in the past. Does HIPAA affect whether or not we can continue to do this?
You can continue to email your patients, but you need to understand that you have to use reasonable and appropriate safeguards to ensure the confidentiality and of that information that's being transmitted electronically. I once heard this description of email that I will share with you because I think it gives those not in the IT world a better understanding of email, and that is, think of an email the same as you would a postcard that's being sent in the mail. When you send a postcard, you've just written a message on the back, and maybe the post office has read it, maybe your mail carrier has read it, whoever got to the mailbox first at your home may have read it. Email's the same way. Anywhere along the way, someone can pick up that email and read it. So it's not a totally encapsulated item and secure item that goes from one place to the other. It can be picked up and read anywhere along the way.
That's great. And in fact, the next question is kind of a follow-up to that. So is it true that email that could contain patient data must be encrypted? Is encryption required at this point or no?
Encryption is officially not required, but what they say, and I'll take just a moment to tell you what their impression of this, and I'm saying there, it's the Office for Civil Rights. They call that an addressable implementation specification. And what that means is
English for.
That's English for. They say what that means is you need to do encryption to protect information both at rest and in transmission to the extent it's reasonable and appropriate to do so. And then they give you some questions to ask which define what is appropriate and what might be reasonable. And the majority of the time people end up back at the theory that it's just a lot easier to encrypt it than it is to try to prove that you've done everything possible and that it doesn't fall into the wrong hands.
In this case, it's one of those examples of an ounce of prevention is worth a pound of cure kind of thing.
Absolutely.
The risk is just not worth it. Another question that we received was, kind of in the form of a statement. Medical practices with phones, laptops, and tablets that leave the office and may or may not have patient data or access to patient data are at risk of HIPAA violation. How do you protect against loss or theft?
We can't always protect against loss or theft of items. We do our best, of course. But there are some precautions and items that you can do in the event that it's lost or misplaced or there is a theft. So again, that's where you can think about something like encryption, because if an encrypted device is lost, it's not required to be reported. Or if you can take some other steps to ensure with software that that information can be erased remotely, that you can track that device. There's lots of other things that you can do as well.
And one of those I know is passwords. We got a couple of questions around the topic of passwords, which is, one of them is, what should covered entities and business associates know about passwords and where they should keep them and maybe where they shouldn't keep them?
That's a good one. I recommend people do not put their passwords on their Post-it notes and attach them to their monitor.
No, huh?
No, not a good idea. And another spot that's typical is to attach it to the bottom of your keyboard. That's not a good idea either. In addition, I will also say it's not a good idea to have shared passwords. Sometimes in a small office, maybe the front desk will have a shared office or administrative password situation. You definitely want to make sure you don't do that type of thing. Also, when you're in certain browsers, you have the ability to check a box that says save my password. Make sure you don't do that and you don't save those passwords. I know it makes it easier to log in, but that you save those passwords for anyone else to access.
Absolutely. Do not save your password because you should be changing it frequently. You could be in violation simply because somebody else logged on there using your password. Two people using the same password could be a violation. You've got to be able to track who is accessing patient information, and if you've got more than one person using a password, you can't track that. That's a violation.
So if you're using a software for your patient management system or any kind of back office software, I'm assuming, of course, because I already know, that you've got to talk to those software vendors and you've got to make sure that they're HIPAA compliant.
Right.
Right. And just because their first initial answer is it doesn't pertain to us, you need to apply the rest of the HIPAA regulations and come at from your own point of view and say, yes, they are storing data for me.
Right. And I would assume that it applies to you unless you have a written authorization from OCR that it doesn't. And good luck getting that.
Yeah. So what is your responsibility if your software company doesn't comply with HIPAA regulations?
You've got to change. You've got to protect yourself. That's the bottom line. If your software is not HIPAA compliant, you're not HIPAA compliant.
Wow. Sobering. We also talked a little bit about strong passwords or password complexity. Do you guys want to address that a little bit too?
Yes. I will actually. We have what we like to call a strong password policy, and this is what we recommend that someone needing to comply with HIPAA would have. And this is a description of what your passwords should contain. They should be 8 characters in length, minimally. They should contain characters from 3 or 4 character groups. That is uppercase letters, lowercase letters, numerals, and symbols. So it needs to have 3 to 4 of those. Then it should not contain the username or any real name. And they should be required to be changed at least every 90 days. And the password history is set to remember and not reuse the last 3 passwords. So you don't want to be switching between one password and then the next time I use the second password and then switch back to the first. That's definitely not something you want to do. And then we need to make sure your system is set to lock out after there's been 5 attempts to log in within the period of 1 hour.
So did you guys catch that? So if someone attempts to hack, the concept behind the strong password is that it makes it very difficult for a hacker to figure out your password, and it makes it so difficult that they move on.
They move on because they could have a program that tries to figure out your password if you don't limit the number of attempts.
Right. So if they try to do it more than 5 times, it locks them out. And that's true on the computer as well as the software, correct? So it's not just one area. You've got to protect all the layers where they can get to your patient data.
Right.
Wow, okay. It's pretty practical when you think about it. And some of these policies have just been good policies up until now, but come September 23rd, they're more than good policies, they're requirements.
There are absolutely requirements, and if you don't follow the policy, then you can be in breach.
Right.
But the explanation is logical and reasonable, and it can be done, and it should be done.
Another question that we received was, I purchased a new laptop. May I use it for work purposes? And if so, how do I protect it?
I would say I would avoid using personal devices for work purposes if it's going to fall under the HIPAA violation or HIPAA rules, excuse me. Using your personal laptop for work purposes, therefore, makes it fall under your organization or company's HIPAA rules and compliance issues. So there can be things that need to be required and done and software loaded on that laptop, and they're involved if yours versus the company's issues. So it needs to be a very clear, defined line. If it's your personal laptop, don't use it for work purposes.
Right. Now, I know this is pretty scary, and I know we've addressed some of these issues, but what we wanted to kind of do is give you some practical do's and don'ts, some tips that, again, we've kind of addressed these from different angles, but just to kind of lay it out for us, let's go over some do's and don'ts for the audience.
Okay. And as you mentioned, we've touched on some of these before, but this is a good takeaway. Do make sure your antivirus is up to date. If you have a server, use a network or enterprise version to ensure that all of the attached devices are in compliance. Next, do make sure you document those definitions and upgrade your system and know the deployment of that antivirus software. Next, don't assume items are properly encrypted. There have been violations and fines by companies who use backup tapes that haven't been properly encrypted. They were removed from the site, not stored in someone's back seat. You can receive fines, and that's definitely a violation. So whenever possible, for backup tapes and other devices, we recommend encryption. But I will say there are various levels, there are varying levels of encryption. So if somebody just tells you it's encrypted, you need to ask more questions than that. Do have a comprehensive disaster and contingency plan in place. Do have and monitor those login attempts we just mentioned. Don't use generic logins, say your front desk, and sharing a password for a small office. Don't do that. Do check the dates of information presented on the internet when you're researching HIPAA guidelines, as Bruce already mentioned. Do consider the placement of your display devices in your office. For instance, maybe your front desk, your receptionist desk, make sure those displays are not visible by those that are patients in your office. Do perform recovery testing of files in a quarterly basis. Do understand that email is not something that by itself cannot be interrupted and read along its path. Do use a strong password policy. And remember, if you're using Windows XP, by the end of April, actually the end of the first quarter, you should be replacing those operating systems.
Wow. All right. Well, what we kind of want to segue into next is some of the risks and the responsibilities, some of the odds. And, you know, we've talked a lot about a lot of different breaches and things that you need to do differently. But I'm going to kind of ask Bruce, what are some of the statistics? What are some of the real-life examples of HIPAA violations?
Well, HHS has estimated that 96% of hospitals are going to have at least one breach a year. Now, hospitals are the best funded, the entities with the most resources. If an entity with the most resources is virtually certain to have at least one breach a year, then think about the small to mid-sized practice that doesn't have, you know, somebody, an IT staff on hand, that doesn't have legal staff on hand. They're much more likely to have a breach and be subject to some of these penalties. There have been audits done recently, and I believe OCR said that 85% of the entities audited had at least one breach of protected health information. From 2009 to 2011, it's estimated that 18 million patients' protected health information was compromised. And from 2011 to 2012, those breaches have increased by 32%. There are, you talked about hackers earlier, there are hackers out there who are now trying to get protected health information and hold it hostage from the covered entity to get payment so that they won't put the information out there and lead to a breach, although there's already been a breach for that covered entity.
Now, didn't you say the other day, too, that there was a requirement that if you have a breach, you're required to notify?
That is one of the incredible things about this law. You have to turn yourself in.
Wow.
You have to report not only to your patients, but if you have more than, and you have to report yourself to HHS and OCR, but if you have more than 500 patient records, you have to alert the media that there's been a breach.
That's not damning.
No, not at all.
Oh my goodness. So what is the responsibility? What is our responsibility?
Well, the responsibility is to take action, really, to make sure that your electronic system is up to date, that it's protected, that you're protecting those records. You have the right IT stuff and the right IT people working for you, and to put your plans, your policies, your procedures in place. You've got people in your organization who you have to have keeping an eye on this. You've got the certain things that you have to do to make sure that the records are protected and that everybody knows how and why.
Right. Well, this is definitely a sobering topic, and we could probably talk about it for another 12 hours today, but I just looked at the time and I realized we're almost running out of time. But, you know, I kind of put myself in the place of someone who's listening in on this webinar. Like I said, if you're not wide awake, you will be right now. I know I'd probably be sweating because there's so much and the rules have changed and there's a deadline, and it seems so ominous. And one person actually contacted us and said, I don't have time to handle everything in our practice, plus the new HIPAA Business Associate Agreement requirement. I don't really understand the technology well enough to know if my vendors are even compliant, and I don't know how to review the HIPAA risk assessment to make sure it meets HIPAA standards. What do I do? And I think it's clear that that's kind of how we can come in. We've put together both the legal side and the technology side, and even if you have legal counsel now, even if you have an IT company, the whole HIPAA HITECH thing is a whole different animal, and it definitely needs to be addressed. And as we mentioned, I'll let you chime in on this, preparing for HIPAA and preparing your practice is a one-time event.
That's right. And, you know, I've been in a couple of different offices recently, and I can see just from brief contact that from the legal side, they're not compliant. And that leads me to believe that from the IT side, they're not compliant either.
Right.
In order, you know, what I can do, what I do for my clients is I can go in, I can see if they're compliant. And I can get them from where they are, see if they are compliant. If they're not, I can get them compliant.
Right.
And the other thing that I can do is once I've gotten them compliant, I can keep them compliant.
Right. Well, we know that the regulations continue to change and the rules are being fine-tuned. And like I said earlier, no one has a crystal ball, not even the lawmakers, to put this in place.
That's interesting because the Secretary of Health and Human Services herself has said she doesn't understand all of the law. So
right.
if they don't understand, how are we supposed to understand, and how's it all going to shake out? Because it hasn't even been evaluated by the courts yet.
Right. So there's a lot that we don't know. There's a lot that's coming up that we don't know about. And kind of to put it in your terms, you know, no one can really guarantee that their patient is never going to have a heart attack. I mean, there's no way of knowing if you'll never have a breach. But just like with a heart attack, you can take measures to reduce your risk. You can see your doctor more regularly. You can eat right. You can exercise. There are certain things you can do to prevent it or at least reduce your risk. And it's the same thing with HIPAA. There are things that you can do to prepare your practice to reduce your risk of a breach or to reduce the ramifications of having a breach. And so that's why it's really not a good idea at this point to stick your head in the sand when it comes to HIPAA, just like it wouldn't be a good idea to stick your head in the sand, have, you know, heart issues and not deal with them. And that's really the point that we want to bring up, because there is a lot to this. And just to kind of pick up where you left off, Bruce, on the screen we have some information about what Bruce provides, but I wanted to ask you, Bruce, how can you help the people who are listening in to prepare for the September 23rd deadline?
Okay, so the first thing that I can do is I can review what they have. I can take a look at their notice of privacy practices, their plans and procedures. Typically for that's a $600 charge. I can take them from where they are now to get them compliant. The day I walk out the door, they'll be compliant that day. And as of right now, September 13, 2013, to get them to that point is typically $1,500. I can get them from zero, where they are today, to compliant and keep them compliant. And to do that, I work with my clients. I was kind of saying the other day, it's kind of like a secret shopper almost. I can stop in and make sure that things at the front desk are compliant. There are not HIPAA violations there. And for that, I do that on a retainer basis of $500 a month.
That's good to know. Okay, so Kristen, let me ask you, so how can you or how can Genesis help prepare the people who are listening in, their IT, prepare them for the September 23rd deadline?
We would do that in a 4-step process. That first step would be an interview. We come to your place of business, we sit down, we review your processes as far as it relates to the IT.
Specifically for HIPAA.
Specifically for HIPAA and HITECH, we inspect your electronic items, your operating systems, your server, to make sure that those items are in place and document those. We compile the findings from what we've learned during our interview and inspection. Then we come back and make recommendations and provide you a final review, where you may be deficient, where you may need software, where you may need encryption, where you may need to do something to be in compliance with the regulations.
And just kind of give them an idea of what that would cost.
Roughly $1,200 depending on the size of your organization.
Okay. All right, well, I'm just going to, again, be real honest with you and say if I was sitting on this call, I would be overwhelmed right now. My head would be swimming. I'd have a whole bunch of questions, and Am I subject to HIPAA regulations? Has any of this been done in my organization? You know, there's been a lot of information that we've thrown around, but it seems like with all the information, it just raises more and more questions. And I think that's pretty intimidating. Did you want to say something?
Yeah, I think you're absolutely right. It is pretty intimidating. There's a lot of information. I know that we have all read and read and read and spent hours looking at this and talking about this. And that's one of the things that we can do, though, for people listening in, is they can take the benefit of all the time that we've spent on this. We can take that off of their plate, do that for them, and keep them compliant so that they don't have to, really they don't have to worry about it because they've got a team of people worrying about it for them.
Right. Well, and if I have all these questions and I'm not really sure if it applies to me, would it be possible for each of us here to say that we would, can we offer the people listening in maybe a free review initially to even find out if this applies to them or if they're even already ready? We don't know. Would that be okay? Can we do that?
I think that'd be a great idea.
Yeah, I think absolutely.
But again, we're up against the deadline, so let's do it this way. Let's say that if they schedule their legal or their IT review and assessment prior to September 23rd, then Bruce and Kristen and Genesis that will be able to offer that first step, the review, for free. Agreed?
Agreed.
Okay. So did you guys hear that? If you are interested in that initial review and you'd like to get that for free, that's available to you. It has to be scheduled prior to September the 23rd.
Not actually completed necessarily, but
Good
call
point.
us before the 23rd so you get on the list to have us come out and review your systems and your legal side of things.
Right.
That's a good point because there's so many people on the call and it's not practical. Again, one of the things that they, being the government, is looking for is that you're moving towards that. Right, Bruce?
Yeah, absolutely. That's what I was thinking as well. That sort of step will help if you should have to appear before the government. Which
nobody wants to do.
Right.
So if you've got questions or you've got concerns or you just want to schedule it, you want to get something, we definitely want to help you. We want to help you watch your back. We want you to be able to protect yourself. And we don't want to see any of our clients run up against a very unfortunate incident. And there is the September 23rd deadline. So if you would like us to answer any questions, if you have any concerns, if you would like a copy of the recording of this webinar, there is a little chat window in the GoToMeeting. And if you'll just give us your name and ask whatever question you want, we'll be sure and contact you. We'll schedule your legal or your technology HIPAA HITECH risk assessment. And for those of you who might be on the road and are listening in by phone and can't see the screen, let me give you a couple of phone numbers. One is Bruce's phone number. Again, he's our business attorney, HIPAA attorney. His phone number is area code 239-334-4067. And you can reach Kristen at Genesis Global Technologies. That phone number is 239-337-2667. So I want to thank you for joining us today. I hope it hasn't been too scary. The good news is there are ways that you can protect yourself. And we're in your corner. We want to help you. We're all in this together because I think even those of us sitting around the table, we're subject to this as well. So we're preparing our businesses as well. So you're not alone. And there are things that you can do, and we would be honored to help you with this. So if you need anything, again, contact us through the chat window or give us a shout. And we hope you have a great afternoon. Thanks again for joining us. Take care.
Thank you.
Bye-bye.
Bye-bye.